I'm the woman present today. I have a statement to make on for the official record before this court goes any further today. I am cognizant and aware that there is no man or woman here today that is in family.
If you want this to be on the record, you have to stand close enough to the microphone so we can figure it out.
Is that in order?
If there's no sense in reading that, it won't be on the record. If you want another record, you can. If you don't want another record, you can stay there.
Can you hear me from here?
Can you hear her? Okay. Why don't you speak again?
Okay. I have a statement to make on for the official record before this court goes any further today. I'm cognizant and aware that there is no man or woman here today that is independently bonded and claims 1-2 under history refers to the testimony. There is no pleadings or bill of particulars from the alleged man or woman swore to under the pains and penalty of perjury of harm, damage, injury, or loss as I, a woman, did cause for which one can provide remedy. For and on the official record, I, as a woman, accept the oath of Carolyn Noakes, woman acting as judge today, to uphold the Constitution for Nebraska State and for the Constitution for the United States of America. For and on the official record, I, as a woman, invoke my right protected under the Sixth Amendment and the Constitution to face the man or woman being the alleged accuser of I stand on my unalienable right protected by the Sixth Amendment. I fall under the protection of the Sixth Amendment, and I invoke and stand upon the Sixth Amendment to face the man or woman bringing forth the claim. The Sixth Amendment protects my right to face the man or woman bringing forth the claim from encroachment by the government by trying to persecute and put the body of I in a debtor's prison for a crime in which no man or woman was injured is in fact a violation of my unalienable right, as well as a substantial rights violation. Is this man or woman known as state of Nebraska here today bonded and swore to under the pains and penalties to testify that I as a woman did cause harm, injury, damage, or loss? If the man or woman known as state of Nebraska is not here in 10 minutes or a phone call is not made to bring the man or woman forth, known as state of Nebraska here in 10 minutes, or no man or woman here today can reach the man or woman known as state of Nebraska, who should be properly bonded for bringing forward a claim and also having a sworn affidavit under the pains and penalty of perjury stating how I, a woman, did harm the man or woman, when I did harm this man or woman, what happened and what transpired. If that cannot be brought forth, this claim or this case is dismissed, discharged, vacated for bringing forth a claim in which relief cannot be granted. I move to dismiss this case. This is a false and fictitious claim being brought against I as a woman without a victim and brought forth through a false and fictitious entity.
All right.
And I also,
that wasn't finished. Not denied. I'm going to proceed.
I also,
to the arraignment.
Do I not have the right to a fair and meaningful trial?
This isn't a trial date.
Okay, so do I not have a right to a fair and meaningful hearing?
So that I can advise you of your rights.
Denying me the right to face the man or woman accusing me today is a denial of due process on for the official record. And
I'm going to allow you to state on the record for one more minute. Would you be quiet, please? I'm going to give you the record, allow you one more minute to state whatever you want on the record. Then I'm going to ask you to be quiet and listen to what I say and answer the questions.
I have a little bit more than a minute.
1 minute from now.
I have a little bit more than a minute to do.
That's not acceptable. Right now is your arraignment day. You didn't file any motions to be heard. If you have motions, those need to be filed, and then they will be scheduled for hearing.
Well, I'm staying on for the record.
If you have 1 more minute, I will allow you to continue to state whatever you want on the record for 1 more minute.
I'm stating on for the official record that if the man or woman is not brought forth, then that is denying me the right to face the man or woman accusing today is a denial of due process and leads me to believe that this court is in collusion with the prosecutor accusing me or causing me harm by way of trespass by conspiracy on and for the official record. And the formal challenge to the 12 presumptions of law. Number 1, the presumption to public record is that any matter brought forth before a state court is a matter of public record when the fact is presumed by the members of the private bar guild that the matter is a private bar guild business matter, unless openly rebuked and rejected by stating clearly the matter is to be on the public record. The matter remains a private bar guild matter completely under private bar guild rules. I, the undersigned, formally challenge the presumption of public record, as it is by definition a presumption by definition and has no standing to merit in presentable or material facts. Number 2, the presumption of public service is that all the members of the private bar guild who have all sworn a solemn, secret, absolute oath to their yield then act as a public agents of the government or public officials by making additional oaths of public office that openly and deliberately contradict
you
their
reached your
private.
time limit.
I'm not finished.
We're proceeding. I'm going on the record.
Agents of the government or
Ma'am,
public
if you don't
officials by making
stop talking
additional
now, I'm going to
oaths
hold you in contempt.
of what
And if you
contempt?
don't-
Is it civil or criminal?
It's a civil contempt.
Do you have
I'm ordering you now to be quiet and listen to my advisements, and if you do not do that,
I'm
with
not
proper
finished
warning, I can have you held in custody.
Okay, and
Ma'am, I will be getting this. No, you need to stop talking or you're going to be placed under arrest.
Okay,
You
if
understand?
this is civil contempt, do you have a contract that I'm in breach of?
This is case number CR20-28 and CR20-27.
There is no man or woman here today, and I have the right to face the man or woman
You're
accusing
the
me.
court proceedings.
No, you're interrupting my
You're
work.
going to be taken into custody.
And what for?
Would the deputy please remove her from the courtroom?
And what am I being held in contempt for? Do you have a contract that I'm in breach of?
You need to leave the courtroom.
Okay, well, on it for the official record, I do charge $1,000 per minute, and if you're willing to do that, you need to sign that order.
Okay, let's move on. State versus Brett Safronic.
No, I don't see that they're here.
Okay, that might be later.
Yeah, he was,
She just asked that you remove her, right? She didn't say put her in cuffs. I don't see an order. I'm just curious why the cuffs are needed. She just asked to be
you're
removed.
probably nerd.
I'm a court observer, so I'm just asking, is there a need for cuffs?
Yeah.
Please get clarification. Thank you. Appreciate that. Near as I can tell, she just wants to have her around and she'll call her back later. Because if it was an order, she'd have ordered her arrest. She just ordered her to be removed. Thanks, buddy.
She wants 5 minutes and then she'll bring her back in.
Yeah, so no cuffs. Thanks.
Please, brother.
Appreciate it. You need to settle the fuck down. You're being dishonorable. That's why you're out here. You can't enter anything on the record until the fucking court case starts. Relax. You got him by the balls. There's no fucking plaintiff. Just relax. There's no need to be hostile. Karen's already exhibited hostility, insurrectious behavior. Don't add to it. Always have to stay on her. You remind me of me when I was first going to court and I was a fucking bull in a china shop. Ask Casey Holbert. I'm just saying, you gotta relax. You're not guilty of anything. Relax. Until the court case starts, there's nothing you said in there that's on the fucking record. Not a fucking thing. There's no plaintiff. Alright, without a plaintiff, your Sixth Amendment is your right to face your fucking accuser. In there when she announces your rights to everybody, you notice how she absconds from saying that? She says you have the right to cross-examine witnesses, you have the right to face witnesses. It never talks about the Sixth Amendment. It never tells you about it. Right, because if you don't know your rights, you don't fucking have rights in this country. Alright? This man took an oath to uphold those rights.
Kendra, let us help you. Let us help you, Kendra.
Corpus Juris Secundum, Volume 7, Subsection 4, all lawyers work for the bar, the crown. Their allegiance is to the court first and foremost.
Who are you?
I'm just a man, nobody special, but I've studied
How old are you?
extensively. Does age really have anything to do with intelligence?
How old is she?
I don't know. Does it matter?
Yeah, it matters. You're taking advantage of her.
How am I taking advantage of anybody?
Well, look what she's getting into.
Somebody sought out my help, buddy. I didn't go
What's she
seek out
getting into?
her.
You're the one that's...
I apologize.
She's family.
We could talk outside at a later time.
Kendra, we love you. Get emotional. I want to help you.
Slow down, breathe, and relax. There's a reason she's not having you put in contempt of court, because what you're talking about is very real. And she knows why I'm here. She tried to steamroll me. I'm not fucking stupid. So just relax. Take your time. Breathe. Remember your objections. Okay? You have a right to a fair and meaningful hearing. That means when one person speaks, the other one shuts up. Unless there's a credible objection. Alright? Just relax. Take your time. You're going to go back through everything you just went through because none of it was even on a fucking record. The stenographer's typing, but it's until the case is called, there's nothing there. It's like trying to buy a car. There's no car on the lot.
Okay, so just do it when she asks for opening statement.
She's going to start out the case. She's going to give the prosecuting attorney, who's not Steve Bowers, coincidentally enough, an opportunity to, explain their case or whatever. And then you have your time to speak and speak. Thank you.
Okay, we are back on the record on case number CR20-28, CR20-29. Ms. Potter, the court had asked the deputies to remove Ms. Potter. Rather than hold you in contempt, I was going to give you the opportunity to leave the courtroom and come back. If you don't stop being disruptive and listen to the court while the court gives you your advisements, you could be held in contempt, and it would be in direct contempt of this court. Do you understand?
I acknowledge what you're saying.
All right. Ms. Potter, can you rewrite and understand the English language?
I am not Ms. Potter. I'm a woman from this state, and I can read, write, and understand English.
Are you under the influence of alcohol or any mind-altering substance?
I am not under the influence of alcohol or mind substance.
Are you taking any prescriptions that affect your judgment?
No, I'm not.
You are picking this up, right? Yes. Were you present when the rights were explained?
I was present.
Did you understand your rights?
I acknowledge what you were saying when reading rights.
Do you understand what your rights are?
I acknowledge.
Do you have any questions about your rights?
I do not have any questions. Actually, I do have a question. Do I have the right to face the accuser?
Yes.
I just put that on for the official record that I have the right to face the accuser, the man or woman, bringing forth the claim.
Is there a plea agreement? No. You have a right to have the information served upon you at least 24 hours prior to today, or you can waive that from what would you like to do?
I'd like to have it served.
Okay. Then we will continue this matter.
I do not consent to continue until the man or woman brings forth the claim.
Okay. You don't have to consent. I'm going to continue it.
Well, on for the official record, I will consider this an appealable issue if the man or woman brings forth the claim is not brought forth.
We'll continue both cases CR20- CR20-28 and CR20-29 to August 27th at 9:30 a.m.
I do not consent without the man or woman being brought forth on for the official record.
Both of those are continued for arraignment. The defendant has requested to be served with the information. And so we will continue to August 27, 2020 at 9:30 a.m. You are ordered to appear on that date and time. Failure to appear could result in the issuance of a bench warrant. All right, thank you, then. You're excused.
That's our hero, ladies and gentlemen. Standing her ground. 25 felony charges dismissed shortly after that court proceeding, all right? So let's get into the semantics of the case, shall we? First, we have an alleged judge who's going to give a right to the hero, but she can't give a right, and she catches herself saying, I'm going to give you a right, and then she quickly redacts her statement without redacting it and changes the form in which she articulates it to, I'm going to give you some time to say what you have to say, because she realized she made a palpable error. It was not an order of arrest or detainment. The question was, would you take this woman out of this room? Okay? That's when I witnessed the aggravated battery and assault by the sheriff, hostilely taking a woman against her will, accosting her, physically assaulting her in an assault and battery situation. absent a warrant, absent an order, okay? And so there was the issue of liability where the judge had so stunningly and cunningly removed herself from any personal liability by just asking if the sheriff would remove the woman. So that's something to note. They had no case. Now, after the fact, this young lady, without speaking to me, had arranged a meeting with the prosecuting attorney and had entered into a contract of sorts. The contract is, in fact, null and void. It's void for vagueness. When we went back the third time I was with her, I believe it was the third time I was with her, and I said, fine, we'll settle this. How do you want to settle it? Well, you just pay everybody back. Well, fantastic. What species? Do you mind clarifying what species we can, we obviously want to remain in honor here. We just want to know what species we need to offer in order to provide remedy. And he could not specify the remedy, so the contract is void for vagueness. Now, he also made a private arrangement with her that he would dismiss all 25 charges. And what, in fact, he did was dismiss without prejudice, which means he can bring it back in 18 months if he so desires, right? So, again, another breach of the contract because he wasn't forthcoming. There was no ascension of the mind. Not only that, it's not on paper. None of it's written down. None of it's signed off on because why? The prosecutor didn't have the cojones to put it on paper and put his wedding signature to it. So there's another debacle there. It'll soon be resolved. But the point is, when you know your rights, you stand upon your rights. Ladies and gentlemen, there's nothing they can do to you. The other thing that was interesting about the ministerial administrator was her order of direct contempt. Ladies and gentlemen, there's only two types of contempt. It's civil or it's criminal. There is no direct contempt, okay? That's a farce. That's a fallacy. It's not reality. It only exists in legal land and is, in fact, an appealable issue for which the ministerial administrator is liable for because there is no immunity for such an egregious breach of public policy, breach of public trust, and breach of their fiduciary duty and oath. Direct contempt of court does not exist unless you consent to it, unless you're silent, unless you acquiesce to it, or unless you say, okay, that's fine. There are only two types of contempt of court, criminal or civil. Civil means that there's a contract that we agreed to that I'm in breach of and you need to prove up. The other thing is, if you're going to hold me in contempt of court, you can't be the accuser, judge, trial, jury, and executioner. That means a whole nother case needs to be set up before a whole nother ministerial administrator in order to prove your claim of how I caused you harm, injury, damage, and loss. And they can't do it, ladies and gentlemen. So I promised you guys earlier that I would play the audio of our hero. You didn't catch it, but the deputy in that, the deputy sheriff actually looked at the sheriff when the young lady was being accosted against her will and said, you better go ask the judge. Which he did a great job of upholding his oath and ensuring that he wasn't going to be held personally liable for what I witnessed with my own eyes. So it's very, 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 very important to study, to become learned, to become articulate, and to teach your offspring these facts. These are facts. They're not drummed up in my head. They're not a fallacy. They are facts. But they only apply if you know how to assert yourself and your rights. So very important. That was one of the most recent court cases I've been involved in. Again, 25 felonies, abracadabra, gone. Just like that. You heard at one point the ministerial administrator ask, has the defendant entered into a plea agreement? And you can hear the deputy district attorney snicker and go, no. And that was her sarcastic way of going, there's no way in hell this woman who knows who she is going to come in here and make an agreement of some sort. we're not there to make deals. We're there to bring the truth, light with honor, respect, and dignity. And there are times where even the Supreme Court has held that the only man or woman that can hold up their rights is a belligerent man or woman. So although it appeared that our hero was belligerent, the truth of the matter is when people try to enforce their will upon you, sometimes you have to become vocal. And you have to be loud and proud and say it loud. Now, you'll notice the right. I'm going to grant you the right to speak for one more minute, and she changes it to, I'm going to give you one more minute, so she changes her statement, of course, because no ministerial administrator can give you a right of any kind, period. And so as she gets into the 12 presumptions of law, all of a sudden, okay, we've heard enough, this is over. Now, why she removed her from the room was so she could reestablish jurisdiction. See, because most people, when they leave the courtroom and come back, think that everything they already said has been established. Couldn't be further from the truth. They're restarting the whole case from point blank. They're starting over again, okay? And so all the stuff that was said prior to her coming back into the room is void. It's gone, unless you have witnesses that will testify as to what was said, how it was said, and they're willing to put asseverations, affidavits together under the pains and penalties of perjury, stating the facts, the whole truth, and nothing but the truth. And so the importance of coming back into that courtroom, prepping her for being able to reiterate everything that she'd already articulated was extraordinarily important. And at the same time, the ministerial administrator realized really quick, attempting to be a third-party, non-biased individual, realized that our hero was not going to leave the subject matter of having her accuser in the courtroom, prepared to testify with first-hand knowledge of the atrocity or the egregious alleged crime that caused harm, injury, damage, or loss, being independently bonded and under the pains and penalties of perjury, making oath to testify against our hero. And she knew, the ministerial administrator knew, that our hero was not going to leave that subject matter. They were beating a dead horse. She was highly trained not to leave that subject matter because that was the only subject matter that had any pertinent relevance. All right? So when the DA is bringing a claim against you, say for DUI, say for whatever it may be, provided there's no man or woman that was injured, it's all corporation commercial stuff, it's all fiction, there never can be a man or woman that's going to testify with firsthand knowledge that you caused them harm, injury, damage, or loss. It's not plausible, ladies and gentlemen. It's a fiction. So thanks for joining me this morning. I hope that helps you guys out. This is an incredible case that I was very privy to be a part of. This woman studied day and night, 16 hours a day. She was looking at 30 years in the federal penitentiary. It's gone. Ta-da. Abracadabra. It's gone. As though it never happened. And it was a great learning experience for her. She lost everything that she loved pursuing this freedom that she so desires. She gave up a lot, ladies and gentlemen, and she's got a lot to fight for now, but she knows in her mind that what she did was right. And she knows in her mind that standing up for herself is something a lawyer could never have done. In fact, I helped her study power of attorney and how to rescind power of attorney from the attorney that was forced upon her. And she got rid of that attorney, and I'll be damned if he didn't sit in the back of the courtroom to watch it, to watch this fire brigade go down, because he said, Kendra, you're going to be doing 20 years. I already worked out a deal for you. You would have done no time. You'd have paid a fine, and you'd have been out. She walked out of there free, with no obligations hanging over her head. You'll notice a number of times she says, I do not consent. These are all things that she's putting onto the record in case we have to go to an appeal, which in 11-0, I've been involved in 11 cases so far where people really, really take to heart what's going on. They listen to me, and we have had 0 opportunities to go to appeal. Why? We nip it in the butt from the very beginning, period. And we stick to the sound principles and maxims of law that apply, which is without a victim, there's no crime. If the glove doesn't fit, you must acquit. O.J. Simpson taught us that shit, ladies and gentlemen. All right? If there is no corpus delicti, no body of a crime, then there is no crime. If there's no mens rea, malium inse, or malium prohibitum, there's nothing, ladies and gentlemen, except for you getting tricked by a bunch of lawyers who manipulate language to get you to consent by tacit agreement or silent acquiescence. And that's why everybody that's in jail today, absent an actual crime where they hurt another man or woman, is in jail voluntarily. So thanks again for joining me. I hope this helps you out. Again, I have a class coming up September 19th, this upcoming Saturday. It's going to be a blast. It starts at 11 a.m. If you scroll through my Facebook wall, you can find the donation page and the details about that. And it's going to be great. It's going to be on equity, trust law, principles of law, okay? Because the law is already written on your heart, ladies and gentlemen. You already know the difference between right and wrong. All right? Everything, statutes, codes, city ordinances, and provisions all apply to Washington, D.C., which is a federal corporation identified as the United States under Title 28, 3002, 15A. All state ofs are actually subsidiary corporations operating under the umbrella corporation of Washington, D.C., Title 28, 3002, 15A. All municipalities are umbrella corporations underneath the state of, whatever state it is, Nebraska, New Mexico, Arizona, you name it, they all operate under Washington, D.C. All right? So where is their delegation of authority to operate outside their 10 square mile area as foreign agents and agency? Absent their delegation of authority to operate outside of Washington, D.C., they also are not conforming to their own provisions, policies that state in public policy that they are to register with the Secretary of State, they are to register with the Attorney General with their Foreign Registration Act and be compliant with the Foreign Registration Act of 1938 and get their Foreign Registration Act certificate. They also need a litany of other things. Corpus Juris Secundum, Volume 7, Subsection 4 tells you the attorney's first allegiance is not to his client first and foremost, but to the court, to the Bar Association, to the state, to his principal, and if anything should ever conflict with his first four obligations, then he needs to take up and protect his first four obligations, which means the client is absolutely obsolete. They cannot have a conflict of interest and represent the client, allegedly, and still uphold their first four duties, which is to the court, the Bar Association, and the state, and their principal. All right? Judge is a banker in Black's Law Dictionary. You look up banker, and it says judge. It's circular in nature, all right? So if the lawyer's first obligation is to the court first and foremost, then he could never actually represent you in any capacity. And we quiz these lawyers all the time. We hit them up with here's an affidavit I just need you to sign off on. You're going to swear under the pains and penalties of perjury that you will uphold the Constitution for the United States of America. You will uphold the Constitution for the state of Nebraska. You will uphold all the amendments. You will ensure that I have the right to face my accuser. You will protect my rights with your life. They won't sign off on it. They'll recuse themselves so fast. Judge, I've got a conflict of interest. I can't possibly represent this person, which we know person is not man, it's an entity. Why? Because the man or woman is coming forward essentially making their claim as being the beneficiary of the estate, which after 1930, all these funds are generated through securities. Everything is a securities game, ladies and gentlemen. The bar attorneys are in control of all corporations. They control the game through financial means as glorified debt collectors and brokers for the bank. And the banksters hire the judges, your politicians, your lawyers, you name it. They're all underneath the thumb of the banksters, which all work for England. We were never free from Britain during the Civil War. Not a day, not an hour, not a minute. We've never been free from them, all right? So thank you very much for your time. I really appreciate it. Again, share this with your friends and family. I don't so often make the courts that I'm involved with public, but this one was an important one for you to listen, how they threaten. Remember, the tyrants, so often when they cannot make you believe their fallacy, will resort to violence. And there's a maximum for that. He who denies principles is nothing more than a brute. And a brute often, their first resolve is to operate in violence, which is exactly what we saw exhibited in this court. But instead of making an order for this woman to be accosted against her will and caused harm, the ministerial administrator asked if the sheriff would remove the woman. And then she allowed the sheriff to take full liability for his own damn actions. She didn't order it because she ain't that fucking stupid. She asked if he would do it, and he graciously obliged her, which makes him 100% liable for everything that he did. And the deputy sheriff is the MVP. The deputy sheriff is the one that shaved the sheriff's ass on that deal. So thank you very much for your time. I hope you guys are having a beautiful, blessed morning. Look forward to seeing you September 19th, where we lay down the critical foundation and principles of law in the exclusive jurisdiction of American English equity. All right? And it's so important. Now, the equity I speak of is different than Roman civil equity. You have to be able to differentiate the two jurisdictions that I speak of. One is private, and the other one is public, commercial. So one is lawful, one is legal. And as soon as you can separate those like oil and water, and you can see the difference in the variance between the laws, you can now compel and move the court in your favor, not some of the time, not part of the time, every time, ladies and gentlemen, provided you have caused no harm to another man or woman. Freedom isn't free. It's time to pull our heads out of the sand and work together. We are the party responsible for having what we have today, for our dereliction of duty to our fellow man, our fellow brothers and sisters. It's time to stand, raise up tall and proud, stand on sound principles, and use logic, rational, common sense, stand in honor with dignity and respect, and always do things in good faith with good conscience for good reason. That's our objective. Violence only leads to mass confusion, which ends up in the end game leading to mass manipulation, which leads us to our present state of mind today. And it's time to nip that in the butt. It's not about race. It's not about the statutes, codes, city ordinances, and provisions. It's about doing right and knowing the difference between right and wrong. And that was all instilled in us when we were in kindergarten. So thank you again for joining me. Look forward to seeing you September 19th, 11 a.m. Central Time here in the United States. And this course will last 10 to 15 hours. It's very, very in-depth. We will not get through it all, but we will get through a great majority of it, enough for you to have a cemented foundation for which you can stand upon. Thanks again.